Good evening, everybody. My name is Jennifer Olmstead. I am the Senior Director of Governance and Operations for the San Diego County Medical Society. In partnership with the Doctors Company, we'd like to welcome you to our latest webinar entitled, Are You Aware and Prepared for New 2023 Laws? Our speakers from the Doctors Company this evening will be Kathleen Stillwell, who is the Senior Patient Safety Risk Manager, along with Richard Cahill, who is the Vice President and Associate General Counsel. Now, before I hand things over to Kathleen, I wanted to remind everyone that tonight's webinar has been approved for 1 hour of CME credit. I'm going to type the link to claim credit in the chat box below. Kathleen also has a slide that she's displaying right now that has a QR code that you can scan that with your cell phone, and that will take you to the link to apply for CME credit as well. As a reminder, this program is scheduled for 1 hour from 6 to 7 o'clock. We are going to have time at the end of the program for Q&A. So if you have any questions, we'd ask that you please just type them in the chat box below, and then I will send those over to Kathleen and to Rich at the end of the program so that they can get answers to all your questions. All right, and now I would like to introduce Kathleen Stillwell. Kathleen?
Thank you. Good evening and welcome to our program tonight. We're on the cusp of summer starting. We appreciate that you're taking the time. The days are longer, so we still have a little daylight, and hopefully it'll still be light out when we finish. I do want to point out that you will have until 5 p.m. on June 1st to claim your CME credit. If you need any assistance, the information is on the slides, and I believe that Jen will be sending the slides out for anybody that requests them. Our program tonight, Are You Aware and Prepared for New 2023 Laws, was developed because Rich and I saw how many calls we were getting from physicians who said, wait, I hear there's a new law that's about something and I don't know anything about it. Is it really a law? So we looked at the laws that out of all the many new laws that were passed this year, and I think I read that there were over 450 laws passed in California alone, but they aren't all relevant to certainly healthcare in your practice. So we really focused on the ones that would be of concern to a medical practice. Many of you might work for a large organization and you have a compliance department who's taking care of all this for you. And we have also on the call, know that we have solo doctors, we have small groups. They don't have the infrastructure. So we really wanted to be able to point you in the direction of where you should look for more information. So we are accredited and you will get 1 credit hour of CME. I'm not going to go over my bio, but I am the Senior Patient Safety Risk Manager with the Doctors Company, and my background is on the slide. And we really appreciate the partnership with San Diego County Medical Society. Rich Cahill is our VP and Associate General Counsel, and I do want to make some remarks because he's amazing, and I also want to acknowledge that he's on vacation this week, but he called in from his vacation to do this tonight, and that's how loyal he is to TDC and to San Diego Medical Society. So thank you, Rich, for that. He has got extraordinary breadth and experience and knowledge about malpractice and laws. And so it's really hard for me to ever consider doing a program without him because he brings so much to the conversation and when we get to the Q&A as well. You know, I like to start with a thought, and this is our thought for tonight. Thomas Jefferson said this, 3rd President of the United States, ignorance of the law is no excuse. And you will probably hear that again tonight because it is no excuse. Saying I didn't know, it doesn't cut it when it comes to a law. The objectives tonight are to increase your awareness about some of the new laws and potential sanctions against your license if you violate them, to help you understand the need to educate your staff and colleagues regarding the 21st Century Cures Act for patient access to unblock all notes in the medical record in an EHR. And that has caused a lot of drama so far this year. So we're going to talk about that, and also looking at being sure that you understand the requirement to have a HIPAA compliant action plan for a patient who says that I don't want that in my record, take that out, that isn't what I said. So we're going to discuss that. So why are we even talking about this tonight? We know that the California Business and Professions Code governs your practice. And if we have advanced practice practitioners on the call tonight, and I know we do, the California Nursing Board and the PA Board and the Department of Consumers, they all look towards compliance with the California Business and Professions Code, and that is what governs the practice for the professionals. And failure to comply with any of these laws that we're going to talk about tonight as well is a violation of your licensure code. And so compliance is the only option, and that's why we wanted you to know about these things. Now, I am just sharing with you the Medical Board of California, some brief information from their most recent available annual report, which is their 21-22 annual report. And I wanted you to look at the most common ethical violations that were reported in the last year. And I highlighted in blue unprofessional conduct and violation of state laws, federal laws, or regulatory rules. Physicians have been harder hit with that in the last year, those two areas, than all the other ones put together. That's why it's important that you know what laws
Kathleen,
are.
this is Jen. Can I interrupt real quick? I'm not seeing your slides. I think we're just seeing you. So can you unshare your screen and we'll try doing that again?
Yes. I do see the slides, Jen.
Are you seeing the slides?
Yes.
Very good. Okay. Apologies.
Oh, now I got to put them back on. I'm bringing him back up. Sorry about that.
No worries. Thank you.
Maybe could somebody put a chat in that they're seeing the slides too, so that we know? Let me put these in. Maybe.
Yeah, so Kathleen, what we're hearing is that they're small. They're at the top of the screen. They're not full size.
Full size. Hello? Jen, are you there?
I am here, but I cannot see that the slides are still small.
Maybe Kathleen, if somebody in the attendees can let you know, but I see full-size slides.
Yeah, Kathleen, if you click on them, you should be able to change their slide.
Rich, are you seeing the slides full size?
Yes.
I am not, Kathleen. Unfortunately, I'm still seeing them small, as I suspect the other participants are as well.
We have you bring the slides up and start with slide 10.
Yes, and I did have somebody else that said they can only see them in a small size on the corner as well.
Okay, I'm going to stop sharing. Apologize for this. As we have some technical difficulties. I've stopped sharing.
Okay, why don't you try sharing your slides again, Kathleen? And apologies to everybody for this right now. Okay, so I'm bringing the slides back over. And I'm doing the slideshow. Now my screen has full-size slides. I can see those as well.
Okay, so we have overcome the glitch. So what I wanted to go back and say about this slide is that This shows us that unprofessional conduct in violation of the laws has become a high frequency with the medical board. And administrative actions, I wanted to show you this because I thought this was positive. In their annual report, they had 8,254 closed complaints. And in that, you of course can see that gross negligence and incompetence was a big number, but unprofessional conduct, there were only 65 licenses that they closed complaints on. I guess the point I want to make is there can be a lot of complaints, but there were only actions taken on 65 for unprofessional conduct, and I think that's a positive. Now I'm going to turn it over to Rich, and he's going to take us through quickly some of these laws. And again, we're just kind of touching the tip of the iceberg, so you know, and you'll have the citation on every slide that will show you where to go to get additional information. Rich, I'll take it over to you on new laws effective January 1 this year.
Thank you, Kathleen. Good evening, everyone. My name is Richard Cahill. I'm Vice President and Associate General Counsel with the Doctors Company. I provide legal support to the Claims Department and also to the Patient Safety Department, and I oversee appellate litigation, and I'm very pleased to participate in continuing medical education and draft a lot of articles that addresses day-to-day issues that practices encounter. I've had more than 35 years experience representing the healthcare community, initially in professional liability and then subsequently focusing on managed care contract disputes and also having to do with privileges issues. Briefly, I'd like to identify some of the laws that we're coming across this year. As Kathleen said, the legislature passed and the governor signed quite a number of statutes into law, but only a handful of those actually directly impact the healthcare community. AB 852 deals with electronic prescriptions, which has become particularly important since COVID in March of 2020. This provides additional exemptions for providers to issue prescriptions electronically. Those can be very expensive, particularly for practices that don't issue prescriptions for Schedule 2, 3, and 4 drugs. It also updates requirements for pharmacies or other authorized dispensers as far as what their requirements are. And as we talked about last year, the Cures Act having to do with reporting of medications and so forth has become very key, and the government is very concerned about this. So prescriber who issues prescription for controlled substances shall document a reason as soon as practicable and at least within 72 hours that there was impracticable or impossible to report this or issue it electronically in compliance with the statute. How they're going to enforce that at this point is unclear because it only went into effect in January. As I mentioned, the Cures Act having to do with other reporting and documentation issues for prescription drugs took well more than a year for the enforcement agencies to come into compliance. The e-prescribing is a costly burden, and it costs providers who write a very limited number as much as $20 per prescription to be in compliance. So here are a couple of the exemptions. It includes a practice or practitioner who issues less than 100 prescriptions a year. They're granted a waiver on other extraordinary circumstances, and those weren't defined. And as typical with so much legislation, it has a broad category so that it enables practitioners to explain what happened and why. However, you must register with the California Board of Pharmacy under these circumstances. Next slide, please. AB 1278, this is disclosure requirements as of the 1st of this year. And also, if you're an emergency room physician, please note that this does not apply to you. It's generally referred to as the Physicians Payment Sunshine Act, which requires disclosure of financial relations between physicians and medical device manufacturers, pharmaceutical companies, and biologic manufacturers. It requires detailed information about the value of anything over $10, which is absolutely nominal, and we'll go through it in a minute as to what types of things it covers. It also says that both physicians and advanced practice providers are required to post a notice in their office and provide notice on the practice website. This week, I went for my annual physical with my physician, and I noticed that he had it prominently displayed both in the lobby reception area as well as in the exam room where I was seen. If you don't follow this, you can be disciplined by the licensing board for unprofessional conduct. If you're curious about what that might include, I direct your attention to Business and Professions Code sections 800 at SEC, and that talks about the California Practice Act and what constitutes unprofessional conduct and the reporting requirements. Here's the posting language that's effective. It requires that detailed information with any value of over $10 from manufacturer or these other entities, including to both physicians and teaching hospitals, be made available to the public. That's to prevent any suggestion that a physician is somehow providing or recommending a service, durable good, or medication because allegedly they may have some conflict of interest. If a physician is employed by a healthcare provider, the employer is responsible for meeting this requirement. I won't go through all this in great detail, but here are the various payment categories that must be reported. And as you can see, it's comprehensive. Entertainment, food, beverage, gift, grants, honoraria, medical supplies, space, travel, and lodging, charitable contributions, acquisitions. It's virtually anything that a physician may receive from one of these covered entities that has a value of at least $10. Kathleen, next slide, please.
I'm advancing it, but I think there's a delay for it showing on your screen.
Okay. AB 1954, treatment and medication using cannabis. I found this interesting over the past several years because cannabis is still listed as a Schedule I medication that supposedly has no medical benefit and that is not something that can be prescribed. That's under federal law. Federal law has not changed, and the identification of it as a Schedule I drug has not been amended by the Department of Health and Human Services or by the Department of Justice. But states, California in particular, have enacted legislation that authorizes the use of cannabis for medical purposes. This particular provision prohibits physicians from automatically denying treatment to qualified patients simply on the basis of a drug screen that's positive or report of medical cannabis use without completing an evaluation. It provides use of medical cannabis recommended by licensed physicians and surgeons shall not constitute the use of an illicit substance in such an evaluation. Interesting conflict, because under constitutional law, federal law takes priority, and yet the government has not made any attempt to interfere with state licensing or use requirements for the medical cannabis. Also provides that physicians and surgeons shall not be punished or denied any right of privilege for having administered treatment or medication to qualified patients. Although in conflict with federal law, the federal government has undertaken no efforts to interfere with state licensing or enforcement rules such as AB 1954. Another one is Section 1184, the Confidentiality of Medical Information Act. For your general edification, that's contained in California Civil Code Section 56 and the following sections. as far as what is and is not required under the state equivalent of HIPAA. This relates to school link services. The bill authorizes providers of healthcare or a healthcare service plan to disclose medical information to a school linked services coordinator. Kathleen, I don't know to what extent over the last 5 months you've had any inquiries about this. I get roughly between 450 and 500 inquiries per month through patient safety on inquiries by our members, and I haven't seen a single inquiry having to do with this particular provision. Have you seen anything from a patient safety perspective?
I have, but it's kind of in the area of someone's new to the school, because what this bill really does is says already you can provide vaccination information to the school without the authorization of the parent. This bill enlarges your ability to provide records on children to a school linked services coordinator. So it could be, as it says in the last bullet, it can be somebody that's located on a school campus or under contract by a county for behavioral health care or for healthcare operations, referrals of students and their families to get services with foster children, etc. So it really takes away the burden of you having to say, I need an authorization signed by the parent. Sometimes there isn't a parent; it can be a foster child. I have the one I've had of it been involving foster children. I think when school starts in summer, August and September, if you're a pediatric practitioner, you might, you need to be aware that yes, you can, but remember that you have to have their request in writing on their letterhead. We don't take any phone calls saying, please send me Rich Cahill's records, because that is.
And I think as a general proposition, if I could, Kathleen, we frequently receive inquiries from our physicians in their practices about inquiries, whether from the coroner's office, law enforcement, or various other oversight organizations seeking information. And the one thing I should stress to you is that there are exceptions to various PHI requirements, but if somebody makes an oral request, make sure that they submit it to you in writing, either through email or fax on official letterhead, with the basis for their ability to receive that information. If you're a TDC member, please submit that to our patient safety department, and under circumstances involving inquiries like this, we're happy to take a look to see if it's a proper inquiry and what the limitations may be. Keep in mind that when you're requested to provide such information, the minimum necessary rule applies, so that you provide the minimum record set that is consistent with what the appropriate request may be. The next one involves AB 2626, Medical Board of California. And this is an interesting one, and it follows from the Jackson case issued by the Supreme Court of the United States last summer, which in effect overruled Roe versus Wade. You might remember Roe versus Wade identified a constitutional right for a woman to undergo reproductive decisions, including abortions. And what that said was different from what's been frequently reported in the news media. All that decision said was that, in their opinion, the Supreme Court concluded that there is no constitutional right to an abortion, but said that it's up to legislative bodies, either on a national level, such as Congress, or on state legislatures, to make a determination as to the rule governing reproductive rights and abortions. California promptly responded with AB 2626, which prohibits medical boards from disciplining a licensee. That would include physicians and advanced practice clinicians for performing an abortion in accordance with existing state law. It just simply makes clear that California supports the concept of women's rights to reproductive health and self-determination. It also prevents the medical board from denying an application for licensure to someone who was disciplined by another state. And the states vary, and we've seen tremendous variance between the states regarding decisions governing reproductive rights and abortion. And if someone had such a determination made by another state which has different rules than California. It specifically provides that California may not discipline a practitioner licensee as a result of that from another state. Also, AB 2098 has to do with unprofessional conduct. And as I'd indicated earlier, if you'd like a more full discussion of what that constitutes, I direct your attention to California Business and Professions Code 800 in the following sections. It's aimed to curb COVID misinformation and establish that it constitutes unprofessional conduct for a physician and surgeon to disseminate misinformation or disinformation. The actual verbiage is set in red on this particular slide. It's appalling to me that no one bothered to consider the implications of that. And as we will indicate in the next slide, a federal judge has subsequently held that for now, that will not be enforced because it doesn't appropriately inform anyone who may be subject to the requirements as to what they are doing and whether or not that constitutes a violation of the statute. And of course, the U.S. District Court Judge William Shub in Sacramento ruled approximately a year and a half ago that it was too vague for doctors to know what kind of statements might put them at risk. His particular decision was based on the right of free speech, but undoubtedly, and I've not read the actual decision because the statute itself, to me on its face, seemed inappropriate, probably under equal protection and due process as well. The order means that it cannot be enforced while courts hear lawsuits, and that may eventually be appealed to the Ninth Circuit. I suspect that the losing party, which at least at this stage is the state of California, may take it to the Ninth Circuit, but it seems pretty clear based upon Judge Shub's ruling and the clear language of the statute that it's not something that can be appropriately enforced. I'd like to spend a couple minutes, if I could, talking about this next slide. I was in college in the mid-'70s in Los Angeles and frequently would review op-eds issued by various healthcare practitioners talking about what was then referred to as a medical malpractice crisis. Suits were causing premiums to skyrocket and so forth. And so as of September of 1976, the legislature enacted and the governor signed what was generally referred to as Tort Reform MICRA, Medical Injury Compensation Reform Act. And it set forth a half a dozen statutes designed to bring it in conformity with the desired effect of making healthcare affordable in California. Several statutes were included, including what most folks understand to be a cap on non-economic damages, notice of intent to let healthcare practitioners have 90 days to investigate a claim before it's actually filed, a clear statute of limitations, as well as economic issues having to do with attorneys' fees and future economic damages that may be awarded. The purpose of those statutes was to make sure that what was being awarded was reasonable and necessary under the law. There have been several attempts over the years to try to change MICRA, usually attempted by the plaintiff's bar. The first was when Governor Gray Davis was elected. One of his campaign promises was that he would support changes to the Medical Injury Compensation Reform Act. Early in his second term, it was clear in 2003 that he was not going to undertake any efforts to change that. And to what extent that decision may have resulted in his recall, I don't know, but he was ultimately recalled. Many attempts have been made to challenge the efficacy and constitutionality of MICRA over the years, and they've all been unsuccessful based upon the way the legislation was written. And you might remember when it was last challenged was in 2014, the consumer attorneys of California attempted Prop 46, which had a number of attempts, including alcohol and drug testing, which I didn't really understand the purpose of that, but the other one had to do with increasing the limits of MICRA. 2 years ago, another attempt was initiated by the plaintiff's bar and ultimately resulted in a compromise between the medical community and related parties and the attorney's bar to make certain changes. I should point out that it didn't substantively change the law of medical malpractice. As we've discussed in prior programs, there must be 4 things that are established. One, that there's a physician-patient relationship, which triggers a duty to provide care consistent with the community standard. Failure to do so constitutes negligence, and that they have to prove to a medical probability that that negligence resulted in compensable injuries. That has not changed, and what we found is someplace between 70 and 80% of claims result in an award, jury verdict, arbitration, or dismissal by the court of a medical malpractice claim. The changes, and I'll briefly go over those with you, has nothing to do with the substantive law leading to malpractice. It's principally changes related to the financial components. One was that it increased the amount of non-economic damages from $250,000. It goes up by $40,000 a year for the next 10 years up to $750,000. It also changed the attorney's fees that could be awarded, which had been changed from traditionally what had been allowed, 40% for a jury verdict, or a third if there was a settlement. Those had been significantly restricted, as well as future economic damages starting at $50,000 to prevent windfalls in the event that the patient plaintiff did not survive. There would not be payments made after the individual's unfortunate demise. All of those went up, but it didn't, at this point, we haven't been able to determine what extent that's had on the frequency of litigation. It stands to reason that if there's greater incentive for plaintiff's attorneys financially to file these, even though the substantive components of a malpractice case have not changed with respect to duty, breach, and causation, that there's a greater incentive for them to pursue these claims. What that turns out to be at this point, we don't really know because we're only 5 months into the new year. Also, there continues to be something consistent with the I'm sorry acts that were initiated many years ago in many states, including in California. And we have a provision that protects the expressions of sympathy by a healthcare provider to an injured patient and their families. It's not unlimited, but it allows them to express empathy, benevolence, and even statements of fault after an unforeseen outcome. If you're a TDC member and you have a circumstance that may involve that, please be sure to call your assigned risk manager. If you're not a TDC insured, please call your carrier, and we have other fine competitors providing professional liability insurance, and they'll be able to provide you guidance as well as to what may be an appropriate expression of sympathy, compassion, and condolence. Also, very briefly, we have another provision, Section 1126, which expands the definition of eligible employer under the program to include 1 or more employees. So if you're an employer with 1 or more employees and you do not offer a retirement savings program, it authorizes and requires you to implement a payroll deposit retirement savings arrangements by the end of 2025. Also, this is something that if you have a smaller practice and you do not have your own HR department or other administrative support, it requires protected time off and the scope of coverage. And this is for a family member under the California Family Rights Act and the California Healthy Workplaces, Healthy Families Act to include a, quote, designated person. And now your employees can identify someone as a designated person for whom they want to use such leave, which is either unpaid under the CFRA or may be paid under the Workplaces Healthy Families Act. This is also something that may be of interest to the smaller offices that don't have administrative support, and it deals with administrative leave. And it amends the California Family Rights Act to require employers with 5 or more employees to provide up to 5 days of unpaid bereavement leave within 3 months of the death of a family member. So in the event that you have that, it may be something that would be worthwhile contacting your carrier if you have some question about that, because as of January of this year, it extends it up to 5 days of unpaid bereavement. Workers' compensation and COVID, as of February 28th of this year, California declared that there's no longer a public health emergency related to COVID. And the federal government earlier this month had the federal equivalent of the public health emergency declaration expire. But what it does, the current rebuttable presumption is that an employee's illness resulting from COVID-19 was sustained in the course of employment for purposes of workers' compensation benefits. So rather than an employee saying, well, this was caused in relation to my employment, they have that hurdle no longer in front of them. All they need to do is make the allegation, and for purposes of workers' compensation, they simply allege that they got it in connection without having to make any proof. Then it's incumbent upon the employer to demonstrate that, in fact, which is very difficult to overcome, that it was as a result of employment. That's been extended for a short period of time. This is the reference I made earlier that Governor Newsom, as of the end of February this year, declared the end of the state of emergency for California. And that's important because California has very strict requirements regarding the practice of medicine here. And what it allowed is for individuals outside the state, under certain circumstances consistent with the state of emergency declaration, to deliver health care. Generally, it was done via telehealth or electronic modalities. And what happened was, as of February, those relaxing of licensing and practice requirements has concluded. So now, if out-of-state personnel want to practice medicine or deliver services within California to patients located within the state, they no longer have an exclusion or an exemption, and they must comply with state licensing requirements under the California Practice Act set forth in the California Business and Professions Code. Also, healthcare insurers must continue to pay for vaccines and treatments for the next 6 months. And you might note that currently there's a big discussion about that between Congress and the current administration, because currently the Congress is attempting to recoup approximately $30 billion in unused COVID payments for such medications. It's currently in effect, but at least in California, the health insurers must continue to pay for that for at least 6 more months. And of course, the federal and state emergency has been declared over, but that's an attempt to, I think, get some continuity of care. I, on Saturday, had my 6th injection and was told that although it's not a new treatment for the Omicron variant, what it is, it's an approved second medication that at least the pharmacist told me that she thought that it would be good for between 4 and 5 months. I think there's some confusion about that, but it was not paid by the federal government, but my health care provider did pay for it. Also, this is a provision about mask guidance. It's not a requirement, it's simply a guidance. When I went to my doctor annual appointment last week, he said that his office practices careful requirements and required all employees and all visitors, as well as patients, continue to wear masks. Also, if you have a significant exposure who tested positive for COVID, you must wear a mask for 10 days. How that can be enforced, I don't know, but at least I think practices are attempting to enforce that as long as they can. As I'd indicated when discussing an earlier slide, the COVID public health emergency under the federal requirements ended as of May 11th. Access to vaccinations, certain treatments such as Plaxilon and Lavrio will generally not be affected. It remains flexible and in place, and as I'd indicated, at least for 6 more months, the insurers will be obligated to pay at least for some months going into the future, and that should help with clarity and continuity of care. The ability of healthcare providers to safely dispense controlled substance without an in-person interacted is affected by the termination of the public health emergency declared by the federal government. And this is going to create some confusion, and the DEA understood that. And so what they've done is to adopt policies in conjunction with Health and Human Services that allow DEA registered practitioners to patients without an inpatient interaction. We're still in the period of time where people can make public comment. We don't have a final rule, but we're hoping that that becomes available over the next several months. Kathleen, have you read anything to indicate how that might pan out?
Yes, there was last week an announcement, and I didn't change the slides because I can't change the approved CME. I wanted to add, though, that there has been an extension for 6 months, that the current situation for telehealth and prescribing remains as it has been, not for out of state, but for in state. And so that's a to be determined what's going to happen. They had public comment. The public comment generated over 38,000 responses. They've never had Federal Register comment of that type of intensity. And my guess is that our government is going to have to probably extend again, because how are they going to get through all those comments? It was from patients, from physicians, from from every walk of life. So what we do know, it is extended right now for 6 months. So we know it goes till the end of the year.
Well, Kathleen, that concludes my portion of the program, and I'll turn it back to you for the remaining slides, please.
Thank you, Rich. No one better than my favorite legal eagle to introduce us to those laws. I want to very quickly, in the interest of time, because I want to have time for Q&A, talk to you about a rule that became final last October 6, 2022, but it came to my attention very quickly last year and at the beginning of this year that accounts that I was talking to accounts, they'd call about something, and I would say, are you following the latest rule that came effective October 6th? They didn't know what the rule was. So I want you to know, if you have an electronic health record, as of last October 6th, the blocking provision that was in the 21st Century Cures Final Rule Act now includes that you must unblock task notes and internal messages in the medical record. In effective January of this year, this is the effect that you have now, that you have to unblock of all staff authored and incidental notes, no blocking access to patients. Patients are able to see task notes from staff members, as well as clinical notes back and forth between providers. I want to make an emphasis on what's in red. Some task notes may not be intended for patients to see, and I say start now that your staff understands that every task note they send through the medical record to another staff member or to a clinician, write it as though the patient is reading it behind your back. Because I will tell you, I do medical record review, and yesterday I was at a practice doing medical record review, and the things that I see in task notes are sometimes very amusing, by the way, but they are inappropriate to be in a task note. So I'm going to give you an example. I had one where the patient called the office and wanted to speak to the doctor. The receptionist sent a task message to the doctor that said, basically, your favorite, underlined favorite, whiny, crabby patient has called 3 times today and insists on talking to you. What should I tell her? And the doctor, in a good humored fashion, wrote back, tell her I died. Well, we can giggle about that. Well, the patient went in the portal and looked and saw that, because they were unblocked now with that system, and was furious and filed a complaint with the medical board for unprofessional conduct. So don't get set up by something like this. You want to be sure that patients are not going to read something inappropriate. I could do a whole program and just show you what not to put in a task note, because I've kept notes on all that. So what's good about open notes? I just want to say that for people who say, no, we can't have open notes, it's actually now been long enough, we're 2 years into it, that we see that it's really been helpful and had a positive effect. 94% of patients and partners in a very large national study reported better understanding of health conditions. And here's the thing about these open notes and the task notes, it's usually not the patient who sees it. The seniors have their young millennial generation, sons, daughters, and nieces and nephews. They go in a record and tell me what it says. They go around and they find this, so they're more high tech. So this is important. So what is bad about open notes? Bad thing is people now go in and say, that isn't what I said. I don't want that in my record. And sure, if it says that they were 5 foot 5 inches, 5'5" and weighed 500 pounds because it should have been 150 pounds, that's something that's legitimate to change, right? And that was a clinical entry change. But if a patient wants content changed, there is a law that you have to follow to do it. And that is, your staff tells the patient, they call and they're upset about something they read. I want that out of my record. Good example, I applied for life insurance. They're going to get my records. It says that I have a history of smoking for 10 years. I want that out of the record. Well, you record what people say. Now, I have doctors call and say, I had a patient today said, I want to tell you something, but I don't want it in the record. I said, what did you say? He said, I was at your recent training that you did. And I said, I'm sorry, but by law, anything you tell me, I have to put in the record. There's no secrets for the record. And that's the truth. If they tell you, so tell them. Don't tell me if you don't want it in the record. Don't tell me. And if it's something that's going to have an impact on your treatment or your diagnosis, I need to know. Now, patients get upset if you don't agree to redact or amend the record as requested, and that's understandable. And they're writing complaints to the medical board about that too. But then when you do your response and say, well, I told them that we have to have the staff told them that it's required that you give us your request in writing, what you want changed and why, and that your request letter will become a permanent part of your medical record. The physician then has to, I'm going to go to another line, they have to respond within 60 days with an opinion on the request. And the physician that wrote the note has to write the response letter. And I know if the doctor died, if the doctor left the practice, then the medical director or the president of the group, someone else has to do it. But they have to read it. And 99.9% of the response letters sound like this. Dear patient, name and follow up to your written correspondence of date with a request for changing your record. Please be advised I have carefully reviewed the record and your request letter and made a determination. The record is accurate. There will be no change in the record. Your letter is now a permanent part of your medical record, as well as this response letter to you is a permanent part of the medical record. So you got to tell people your letter is going to be part of the medical record, because that has a lot to do with it. It'll stop them from sending it. They have to say what they want changed and why. I do want to say what notes can still be blocked from the patients. It's very limited. It's primarily going to affect psychiatrists, or if you believe that the patient would be harmed or that another person could be harmed by reading a note, and you have to protect the security of another person, for instance, a mother's health information in a child's record. But it's primarily going to address mental health notes that can be blocked. So this is what you have to do. Slide 39 is what you have to do. I've already went through this. This is a HIPAA requirement. It's not the TDC law. It's not Kathleen's rule. It is a federal privacy law. This law for an amendment or a redaction has been in place since 2013. This is not a new law that was put in place for the Cures 21st Century Rule. So again, that's very important. This is a sample for you to just see. If you're a TDC client, you can call us. We'll help you and take you through the letter and assist you with that. There also is a law that took effect last year, and it's still in effect this year, requiring CME to be approved has to include content with cultural and linguistic competency. I'm not going to review these slides, but I could not get this approved if I didn't have content. But I think it's suffice it to say you serve a very culturally diverse population, and it's important that you're sensitive to the culture of your staff, that you're sensitive to their culture, and that everyone is treated with, of course, respect, deference, and with compassion, care, and concern. So we don't have any issues coming out of San Diego or any of our physicians that I see, but we do see from time to time that we have physicians who get reported to the medical board because it's the perception of the patient or the person who was with them in the practice that they were not treated respectfully, and then they have that. We hope you have a situation that you've got documentation documenting who said what with quotation marks. So I'm going to just jump through this, and oops, my last slide is one of my favorite. I think that is, it's real windy where I want to end with this comment from Buddha. Look at when he lived in the BC period. He was very knowledgeable to see what was going on, and now my computer, not even touching it, it's jumping around, so I apologize for that. So I want to close with the Buddha quote, which I had there. Hold on, I have to get my paper quotes here. You are your own master and make your own future. And you work hard to get your license. You work hard to practice your brand. Your brand is gold in San Diego, and you're doing a great job. So, TDC, myself, we thank you for being out there still. Now I'm going to turn it over to Jen, our host, and ask Jen, do we have any questions?
Thank you, Kathleen. Yes, we do have a couple questions. Your volume has been going in and out, so just an FYI on that. Hopefully you can hear this okay. First question is, if suspecting a child abuse or elder abuse and reporting to CPS, APS, of course, I assume the records are protected from open note?
Yes, you can. That would be something that could be harmful. You're a mandated reporter, so you can block that note. Absolutely.
Terrific. And then for those who work part-time, does bereavement and family leave or retirement also apply?
Rich, I don't know the answer to that. The law just says if you have one or more employees on the time and 5 employees, I think it was, on bereavement.
I haven't seen anything on that, and it's an excellent question because so many practices are going to shared employees, part-time employees, telehealth type employees who only work a couple hours a day or a couple days a week. It would depend upon the definition of employee, and I suspect that we'll get further clarification on that. But at least at this point, it just simply identifies employees, and it'll eventually be defined better, I suspect, under the labor and employment codes as to what constitutes an employee for the purposes of either bereavement leave or Family Medical Leave Act.
Thanks, Rich. And going along with that, must one provide a retirement plan for an employee who works part-time, for example, only 6 hours a week?
Same sort of thing. I don't know, because I don't know how that'll ultimately be evaluated. At some point, I suspect that there'll be a regulatory clarification by the state, but that's the problem when they just simply talk about employees. It seems like it's real clear. But over the course of the last 3 years since COVID, what constitutes an employee has become a more fluid concept, and we'll have to see as we go forward with that. Kathleen, do we have any employment counsel that we occasionally will refer our folks to that they might be able to get information along those lines?
I will look into that, but I looked into this before when I put this program together because I knew that could be a question. And at the time, the law, it just took effect in January, and it wasn't clear. It didn't distinguish part-time, but just as you said, the attorney said they anticipate that there will be some modification because it's too broad. And also, I wanted to say on that Cal Savers requirement by December 21st, 2025, it's my understanding, but again, this is not any legal guidance. It is my understanding you're only required to set up something to the patient, the employee can contribute to, but the law does not require the employer to contribute to it. It's for the employee to have a fund to set aside money. It doesn't stipulate that the employer has to put money in there.
Okay, Kathleen, what about platforms such as Microsoft Teams, Skype, and emails? Is patient information like the name, date of birth, is that information discoverable, and should they not send that type of information within the platform? Can they send patient info via email if it's encrypted?
I would say only encrypted by email. I would not send anything by Teams. It's not, unless your IT people tell you have encrypted Teams, which I don't know. We use Teams and we are told not to send anything of any sensitive nature by Teams. And so the whole thing is it needs to be encrypted. So I would say check with your IT people to see if your Teams is encrypted. And on the Zoom platform, the same thing. Also, you have to look at, do you have a business associates agreement with someone that you have if you're using anything like a Zoom platform or a Teams platform, you would have to have a business associates agreement with that organization, which means if there's a breach, it's on the fines and penalties are on them, not on you. And so far, I haven't heard anybody has a business associates agreement with these platforms. Have you, Rich?
I haven't, and again, it's an evolving dialogue, and particularly with discovery. I think we'd mentioned in an earlier program that when I first started doing this work in the early to mid 1980s, courts were reluctant to allow discovery to be broadly applied to various different types of medical records or things. But what's happened over time is that whether it's relevant or reasonably calculated to lead to the discovery of admissible evidence. And so courts left their reticence behind, and it's a very broad and liberally applied statute at this point, particularly now that we have open notes. And I should mention that Kathleen and I did 4 articles about a year or so ago talking about open notes, including the changes that would go into effect this year. And if you want to Google Kathleen's name, open notes and TDC, you'll come across those, and those will be very helpful so that you have a better understanding about open notes, what's discoverable, what can be hidden, and so forth. And I recommend that to you.
It does look
I do want to say something that keeps surfacing with using, if you have office staff using their personal phone to text patients or email patients and even call patients, be aware that if you get involved in a litigation, they can require metadata from your employee's phone and have access to everything on the phone of your employee. And if employees knew that, they would not want to be using their phones. It's recommended if you are in a situation where your staff is using their personal phone, number one, it has to be encrypted. Number two, they are at risk that everything on their phone can be taken for a litigation. So the response would be buy a phone that you can text on, just a cheap phone, a burner phone. You don't need a high-end phone that's an office phone. And it's really recommended that you're not having your staff using your phone. The same thing if you're using your personal phone for things and texting and it's not encrypted, it's a HIPAA violation if your phone's not encrypted. And unfortunately, your phone and everything that's on your phone and in your cloud can be discovered in a litigation. And I've seen some really tough situations where information came out that way in litigation. So we're just trying to make sure people understand, don't be at risk. Don't put your employees at risk.
Kathleen,
any other questions?
Yeah, just a couple more. Can you discuss the exact language to post in a provider's office to comply with AB 1278 once again?
That was, I think, on slide. It's on a slide. I'm going to go to the slide. Hopefully it'll come up.
Maybe 16.
It wasn't in my, here it is, right here. It's on slide 16, yes.
Right.
And it's where the little orange caret is, where it starts with the federal physician. You know, you don't have to put what's in red, just what's in black and highlighted, that part. The Federal Physician Payment Sunshine Act requires that detailed information about payment and other payments of value worth over $10, blah, 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 and teaching hospitals be made available to the public. That's the posted language that's required. And also, if you want to check your own name and see what's been posted by vendors for you, you can click on this Open Payments Data site, and it will come up and it will ask you to put your first and last name in, your city and state, and then it'll search, and you'll see if somebody, if it was a pharmacy, a medical device, or a biologics company that brought you lunch, took you to a baseball game, whatever, they have to put that in there, but you have to as well now. That's what the law is that it has to be there. So I have people saying, do I have to put it in if the vendor put it in? I said, you know what, the law says you have to post this, and so then you better check to be sure the vendor put it in. So it's slide 16.
Got it. Rich, with the COVID-19 emergency orders ending, that ended in February, can they continue treating out-of-state patients on telehealth?
And that's the interesting thing, and it's been the law in the United States under constitutional law that states determine the licensing requirement for the licensees within their jurisdiction. So California can have its own rules, New York can have separate rules, and the federal government could, under the Supremacy Clause, get involved, but for whatever reason, historically chose not to do so. So what you do in California, if you're licensed in California, you can treat patients in California with telehealth, but now you can't do it from out of California unless you're licensed in California. Same way was the reverse. Let's say you're licensed in California and your patient is physically residing out of state. I see this frequently with students who go out of state for college and they want to continue treating with their provider, whether it's a primary care physician or a psychiatrist or otherwise. The determination is not California law, but where the patient is actually located. And there's a great deal of variation. Some states like Washington, for example, are very lenient. Other states like California are not. So you'll want to make sure that you're in compliance with the state licensing requirements where your patient is located. There's also the Uniform Compact having to do with interstate licensing. I haven't found that to be particularly helpful, but it might expedite it if, for example, you have a lot of patients in Arizona. I had some practitioners who practice both in California and in Hawaii and are licensed in both places. But what happens if one of those patients then goes to another location? They have to be in compliance with the other state. So I know that's a difficult answer because it doesn't help you, but it's because states have the right under federal and state law to determine what the licensing requirements are. And now that as of May 11th, as I'd indicated in one of the earlier slides, the federal public health emergency declaration is no longer in effect.
That was a great explanation. I also, because I've had probably I looked up many states, and like February 28th, we ended our emergency. Other states have too, so they're not allowing the same thing.
Kathleen,
anymore.
Kathleen, you seem to be breaking up again. Let's see.
Sorry.
That's okay. Do you want to?
So the other. Can you hear me?
You're cutting in and out.
Yeah, Kathleen, most of what you're saying right now is garbled.
Yes. Yeah, we can't seem to hear you too much, Kathleen.
Okay.
Well, I think what we're going to do right now is we are going to end right now. If anybody has any other questions that we didn't get to, please feel free to send them to SDCMS at sdcms.org so that I can pass them on to Kathleen and Rich. We want to remind you again that tonight's presentation was good for 1 hour of CME credit. Kathleen had the slide right there that you can scan, and that will send that link directly to where you would go to claim your CME credit. And if anybody would like to receive the slides from tonight, please feel free to send a request to SDCMS at sdcms.org. Thank you all for joining us tonight. Thank you, Kathleen and Rich, for a great presentation. We appreciate all of you being with us this evening. If anybody has any suggestions for future webinars, also please feel free to send them our way. We are always looking for content ideas, and we really appreciate you taking time to be with us tonight. So thank you. Have a good evening, everybody. Good night.